Okay, we're continuing on. We're starting on chapter 7, which is titled Child Custody Visitation and Parties of Rights of the Third Parties. This is a tough chapter because we're talking about children. And this is what most parents fight about when they terminate their marriage. There's lots of different reasons why. It could be that, one parent has moved on and is with someone else and the other parent is jealous. It could be that, they spent a lot of time together and now they have to split their time, and that's not always the easiest thing to do. It's a tough area of law. And it doesn't end after the marriage is terminated. Something that you need to remember is after the divorce is over, if you have minor children, the court retains jurisdiction over them until they reach the age of majority. So the court is constantly continuing to intervene when parents can't resolve issues. This is one area, sorry, I was outside and the allergies are getting to me. This is one area of law where we use mediation quite a bit. And before we even start this chapter, I want to go over what mediation is. Mediation is something that we use, and it's called alternative dispute resolution. So there are different ways of doing alternative dispute resolution. Mediation is just one of them. Alternative dispute resolution is what it sounds like. Instead of resolving our disputes using the court, we're going to use another method, an alternative method. So alternative dispute resolution is where the court encourages litigants to resolve their disputes away from the court. There are lots of advantages to this. The first is a lot less expensive and time consuming. And everything that happens in court is public record. Anytime you see like Ancestry.com or any of those services where people or companies are tracing things that happened in families, excuse me, a good bit of it comes from public record. So if there are court documents that, can be accessed by these companies, they do, and then they kind of glue everything together into historical narrative. If you really care about your kids, you really don't want their lives out there as part of the public record. It's not fair to them. They have no control over it. You are putting their lives out there for everybody to see. And as they get older, if they realize that, there are lots of layers that have to be unpeeled from the onion and resolved. So the courts recognize all this and therefore really, really encourage parents who are technically litigants against one another to resolve everything that has to do with the children away from the court. Right? Judges know that they are, strangers in robes who are elected who have never spent time with these children or with you as parents. Judges get all of that. They don't want to have to decide things that you as parents should be able to work through. Unfortunately, a lot of parents can't. And then the courts get involved. Anytime you terminate a marriage where there are minor children that were born as issue of the marriage or were adopted during the course of the marriage, the court has to know, okay, where are these kids living? Where are they going to school? Who's paying child support? When are they going to spend time with mom? When are they going to spend time with dad? Because parenting is a two-person job. And the court wants to work with parents to facilitate that happening. Okay? So, alternative dispute resolution is a way that the court can encourage you to get that done. Some jurisdictions require mediation before a trial that centers on the topic of parental rights and responsibilities. And again, anytime I say parental rights and responsibilities, I'm talking about visitation. So some jurisdictions will do that. If you've resolved everything in your divorce except for how the children are going to be raised, the court may say, hey, go off and see a mediator and see if you can get this resolved, because it's a lot cheaper and quicker and better for the kids. So exactly what is mediation? Mediation is where there is one individual who sits in the middle, who then meets with mom separately and then meets with dad separately, writes down mom's concerns, writes down dad's concerns, tries to come to a resolution that both mom and dad can accept. Sometimes it works, sometimes it doesn't. But lots of times the courts will say, go to mediation first, because this is crazy putting your children through a trial. Okay? The other thing that all courts do is in the separation agreement, which, again, as a reminder, is your contract or your order from the court that says, this is how we're splitting stuff up, this is how we're raising our children, this is how we are paying our debts, this is who's taking care of the pets, this is who's going to pay child support and how much. It is how you resolve everything, that separation agreement. If you have children, there will always be a final little clause when it comes to parental rights and responsibilities that says, if mom and dad have a disagreement about visitation, they have to go to a mediator first. They can't come to the court first. They must try to mediate this first. And then if mediation doesn't work, come see us. Why does this work? Well, because mediation costs money. And just like it costs money to file for a divorce, it costs money for lawyers, it costs money if you go back to the court after your divorce and say we're having trouble, it costs money. Mediation is the most cost-effective way of resolving everything. So if after the divorce is final, parents are starting to have disagreements about visitation and who gets the kids when, a mediator must be agreed upon. Both parties have to pay the mediator some money, and the same process. Mediator sits here, meets with mom, meets with dad, has a proposal, and tries to get both sides to agree. The added part that makes this a bit more persuasive after the divorce is final is that the lawyers for mom and the lawyers for dad are usually going to say, hey, the judge is going to ask what the mediator recommended and probably is going to order it. So maybe you guys want to come to terms with this before you spend money on a mediator and then spend money going back to court. So after the divorce is final, alternative dispute resolution is pretty much mandated by your agreement, and then hopefully you don't come back to court. Okay? Let's talk a little bit about the history of custody, because there is a history to this, just like there is a history with alimony, right? The structure of marriage has changed. It used to be, back in the days of alimony, where you had this contractual arrangement where Husband had responsibilities, wife had responsibilities. If the marriage terminated, those responsibilities didn't end. So with custody, or visitation, or parental rights and responsibilities, however you want to term it, because it was mom's primary responsibility within a marriage to raise children, pretty much that's what happened. And dad could come visit, or could take the kids periodically to go visit. This started to change in the 1970s. Again, we had the women's liberation movement. We had a bunch of Marxists that came out of the woodwork who said, no, we'll have the state raise children. Just send them to daycare, Mom. You go off to work. And really, that's what Betty Friedan told everybody to do. And again, I lived through it. So I'm a primary source. And so you ended up with a situation where moms and dads were viewed as being the same in their child rearing responsibilities. And over time, the courts said, you know what? I think that kids need to spend just as much time with their dad as they do with their mom, and so we're not going to worry about kids only being placed with their mom. We're going to put in place this test called the best interest of the child test, where the court looks at how the household runs and then says it's in the best interest of the child to maintain stability while maximizing time with mom and dad. Okay? It's in the best interest of the child. So, if dad works midnights and mom works during the day, then the courts have determined that it is best for child to go after school with dad until mom gets home from work, and then mom can pick him up, and then dad can go to work, and the child gets to spend time with both parents. The problem is, there's a reason why parents got divorced. They don't like each other. And the other problem is life continues on, and you have new boyfriend, new girlfriend, new spouses, and so you have more people that you have to consider in the pot. There might be stepchildren, there might be new children that are born. The world changes. And so not everything can stay static. So periodically these parenting arrangements have to be modified. People get new jobs, people move. What the courts have done is come up with some standard orders of visitation or parental rights and responsibilities that we can then play around with. And if you can't agree, then the court's just going to say this is the order. Okay? Now, there's the first order, the first kind of order, standard order, which is just called your standard order of visitation. Now, with a standard order of visitation, one parent is named the custodial parent. That means that that parent is where the child primarily resides. That is the parent who will decide what school district the child goes to. That's the parent who will pick the doctor, the dentist, right? That parent primarily runs the raising of that child. Okay? That's called the residential parent. The other parent is obviously the non-residential parent. The non-residential parent will visit the child, or when I say visit, they will pick up the child, and the child will either come to their home or they'll go do something. Typically in the standard order, it's one day during the week after school, maybe from 5 to 9, and then every other weekend. from Friday afternoon till Sunday night. That's a standard order. What do we do with birthdays? What do we do with Mother's and Father's Day? Oh, don't worry, the standard order has worked that out too. On the child's birthday, every other year. Mom gets them when they're 1, Dad gets them when they're 2, 3, 4, you get it. Father's Day, doesn't matter whether it's Dad's weekend to visit or not, Dad gets the child. Mother's Day, same thing, Mother's Day. Christmas, every other year. New Year's, every other year. Christmas vacation, fitty. We break it up. Okay? So if you can't agree on what you want your arrangement to be, the court's going to order a standard order, and they're going to pick one parent to be the custodial or residential parent. That's what happens. That stinks on ice because it's rigid and it doesn't fit everybody's world. Most standard orders of visitation say Wednesday night from 5 p.m. to 9 p.m. What if piano lessons are at 7 o'clock on Wednesday nights? What if I don't get off work till 5:30? I can't pick up my child until 5:30, 5:45. So what most people do is they modify the standard order of visitation. And the modification, of course, is tailored to everybody's individual situation, but typically it will be 2 midweek, maybe Tuesday, Thursday, and every other weekend. And if the mom and dad live close enough to each other, and they're within the same school district and it's not a big deal, the non-residential parent will keep the child from Friday night till Monday morning and take the child to school on Monday morning. We're maximizing time, right? And we're not being disruptive of the child's world too much, okay? This is for people who live fairly close together. Obviously, the further you live apart, standard order isn't going to work so well, okay? But for most people who are committed to seeing their children and want to live in the same area, a modified standard order of visitation typically is what works, right? And again, you can modify it because, maybe I'm a nurse and I'm off every other weekend, but every other weekend I have to work. We can negotiate so that when I'm at work, you have the children. Or maybe I work from 7 to 3, and it's easier for you to take the kids to school and me to pick them up from school. There are all kinds of modifications that can be done. So the standard order typically will be a starting point, your standard order of visitation. But the important thing to remember is we have a residential parent and a non-residential parent. Non-residential parent doesn't get to choose doctors, dentists, doesn't get to choose school. The residential parent does. Okay? All right. So what if we live too far apart for a standard order or a modified standard order of visitation? Well, we're going to have a long distance visitation schedule. And with a long distance visitation schedule, I'm obviously not going to get to see my children all that much if I'm the non-residential parent. Well, wait a second. How do we get to choose who's the residential parent? Remember, the courts want what's in the best interest of the child. So if I get a divorce and I have a job in Albuquerque, New Mexico, and my husband stays here and has family here, and the children are going to stay in the same school district and have the same friends and be able to do the same activities and see relatives and have continuity in their lives, guess who's going to be the residential parent? Not me. Not me. It's not in the best interest of the children to uproot them and move them. Now, what if dad works crazy shifts and there are other issues with dad, that he's not a real good parent, and, we've got allegations of alcohol or whatever? Okay, then maybe it'll be in the best interest of the children. But if we're just talking about location. If you're disrupting, uprooting the children and the other parent isn't, you're not going to be the residential parent. So the non-residential parent obviously can't see the children all that often. The non-residential parent will get the children for the entire summer. Depending on how far away you live, if it's feasible, long weekends you will have with your children. All of Christmas break, all of spring break. Basically, when the children have a vacation from school, they're with the non-residential parent. Well, if I live in Albuquerque, that's a pretty expensive thing. How does it work? Well, the rule is whoever is getting the child has to pay for it. So I would have to pay for, say, a plane ticket for my children to come to Albuquerque, and my ex-spouse, the father, would have to pay for a ticket to return to the Youngstown area. Okay? And by the way, that's the same thing with even the standard order of visitation. If it becomes a really big issue, we split up costs. Okay? Now, that really stinks because you're really not seeing your children. It's like strangers coming to visit you on the weekend, isn't it? So what now the courts are ordering is electronic communication. That there has to be a phone call, FaceTime, Zoom, whatever, usually a minimum of once a week. And that when there are sporting events, band recitals, dance recitals, the residential parent has an obligation to either stream it or record it and send it to the non-residential parent. That's a big deal. It actually helps non-residential parents dramatically when it comes to, knowing what's going on with their children. An issue usually arises with, the child's too young to have a phone. And the courts will say, well, the child can have a phone only for the purpose of this phone call, but the child is going to have a phone. Who pays for that phone? The non-residential parent. Okay? Because again, it's just like, I'm getting information, I'm getting communication from, therefore I have to pay for it. Okay? So that's a long distance visitation. And again, we start with the standard order and we try to modify it. Maybe Christmas is a big deal in my family, but Easter isn't. So maybe you have the children on Easter and I have them on Christmas. Or, maybe you don't want the children for the whole summer. Maybe we can do half the summer. You at least have a starting point when it comes to the long distance standard order. Okay? Now, we have something called shared parenting, which is another option. Shared parenting can only be agreed to by the parties. So the court can't order shared parenting. But if you're having a dissolution and you're agreeing to everything in your separation agreement, or you're having an uncontested divorce and you're agreeing to everything, you can come up with what's called a shared parenting arrangement. I highly do not recommend them. Again, there's a reason why you got a divorce. Shared parenting operates under the premise that parents can be adults and can agree with one another, at least when it comes to raising their children. I'm going to tell you, I practiced this for about 25 years and I never saw it happen. Pretty the world's changed, but I don't think so. Typically what you do is you try to pretty much evenly split the time between mom and dad. Some shared parenting agreements are 1 week you stay with dad, 1 week you stay with mom. I'm going to tell you that gives kids whiplash. In order for a shared parenting plan to be in effect, you have to be in the same area, you have to be in the same school district, otherwise it doesn't work. Shared parenting is also different from a standard order of visitation because, remember, with a standard order or a modified standard order, there's one residential parent and one non-residential parent. With a shared parenting plan, whoever the child is with is the residential parent at that moment. It's crazy. So you have two residential parents. It just depends on who the child is with, who's the residential parent at that moment in time. That becomes a real headache for schools, because in order for a child to be enrolled in a school district, there has to be a residential parent that they can look to and say, yes, they are residents of our school district, therefore the child may attend. Okay? And so with shared parenting plans, we actually make it as complicated as possible, and we have come up with residential parent, right? Two residential parents. But then somebody's got to be the residential parent for the purposes of school, for school purposes. So you have to designate who is the residential parent for school purposes. And then the school gets a copy of your separation agreement, which is great because the whole world needs to know your business, right? So shared parenting, again, only if you agree. Most shared parenting plans look like a modified standard order of visitation, except for the fact that you have two residential parents. That's typically what you'll find with most shared parenting agreements. Remember, again, the court cannot order it. You've got to come to an agreement about it. And I used to strenuously object because, again, you're borrowing trouble, depending on how old your children are. Right? But the younger the children, the more chances you have of having a problem later. Okay? So those are our three major kinds of visitation order, right? Our standard order, which can be modified, our long distance order, which can be modified, and shared parenting, which again has to be agreed to by the parties. We also have something called a transitional order. What if mom and dad have been going through a contentious divorce and the kids haven't seen dad for 2 years? We have something called a transitional order, so we are reintroducing the children to their parent. And we do this a lot more in juvenile court, where we're not dealing with people who are married. We're dealing with people who are not married, and sometimes dad didn't even know he had a child, or mom said, you're not going to see this child until you pay me child support, and the child could be 2, 3, 4 years old before the parent gets to see the child. We're going to talk about this in 2 weeks when we talk about juvenile court, but just keep this in mind that we do have transitional orders where we try to introduce the children to their parent who has been absent for whatever reason. Okay? Now, why would we not have why would a parent not be allowed to see their child, right? We're talking about the fact that this is always going to be in the best interest of the child, that by and large it is in the best interest of the child to spend as much time as possible with both parents. Except, okay, what are those exceptions? Well, of course, when it's not in the best interest of the child. What does that mean? I'm talking gobbledygook, right? Well, where there's abuse or neglect, an unsafe living environment, one of the parents has a psychological illness, something that would put the child's life in danger. Let's say dad's a drug dealer. I've had many of those cases. Dad's a drug dealer. Sorry, can't see your kid. Maybe dad has a physical impairment because dad was in a car accident and had a brain injury and physically can't take care of the child. Okay, you can't be a residential parent if you can't take care of your child. Excuse me. But we will work with you to try and put together some way for you to have some contact with your children. Where it's a danger for your child, you're not going to be the residential parent. And we can go so far as to say You are so dangerous that one parent will have sole custody of the child. That's a pretty drastic step. Why would the court do that? Again, maybe one parent's in prison. Maybe one parent has a psychological impairment. Maybe they have abused the child. Those are the biggies. Why you would not get any custodial rights at all. You would not be the non-residential parent. You're just the parent. And the other parent has sole custody. They can decide everything about that child. And you don't have any kind of rights of visitation at all. Those are harsh. Those are not the usual case. But they do happen. Okay? When a child reaches the age of 12 in Ohio, the court will consider what the child's preference is. What does that mean? The kid gets to say, I'm mad at mom this week, I don't want to live with her anymore? No. But what it does mean is that the court, as one of many factors that it will consider what the child's preference is, and will listen to the child about why this is their preference. By the way, the court at any time, the judge at any time can say, I just want to talk to the kids. And the kids can come in and talk to the judge in the judge's chambers, which is another fancy word for saying their office. And they sit down and they have a chat, and the judge gets to know the children over whom the judge will retain jurisdiction until they are adults. So that's kind of a big deal. The other thing that the court will look at if parents are fighting is what the guardian ad litem has determined about who's the best parent. Remember, a guardian ad litem is an attorney for the children that is typically appointed at the first pretrial hearing of a divorce. In most counties, that will be a lawyer. That lawyer will meet with the children, will meet with the parents, will visit the school, will look at school records, talk to coaches, talk to the parents in their home, will look and see if there's bedrooms, food in the cabinets, all of the above. And then we'll prepare a report and recommendation for the court. And the court usually follows it. Because the guardian ad litem is the eyes and the ears for the judge. So if you're fighting about custody, who's going to be the residential parent, and there's a guardian ad litem, you want to get ahead of the curve. And you want to come to an agreement before the guardian ad litem comes out and makes a recommendation. Because in my experience, it can go either way. You could think, oh, this guardian really thinks I'm the best. It doesn't turn out that way. And if the judge makes the order, that's what you have to do. Again, you are surrendering your rights as a parent to a stranger in a robe. And so coming up with some kind of an agreement is the best way to approach this. Other states have a different idea about preference, child's preference, by the way. That is just controlled by statute. And so you have to look in every state statute to see about that. Another thing that is controlled by statute is grandparents' rights. Different states have different rules about whether or not a grandparent has any rights to visit with their grandchildren. Okay? You've got lots of situations where grandma really has been the primary caregiver for these children. And then the divorce happens, and because the residential parent hates the mother-in-law, they don't get to see the children anymore, and they're heartbroken. They're heartbroken. And in Ohio, there's nothing you can do if you're a grandparent. There's no such thing as grandparents' rights in that kind of a situation. The only way a grandparent can have any rights to a visitation with a grandchild in Ohio is if their child who is the parent, has died. So if I'm grandma and my son dies, I have the right to go to court, to domestic relations court, assuming, my son and my daughter-in-law were divorced, and say, hey, court, I want to see my grandchildren. I'm asserting my grandparents' rights through per stirpes, through my deceased son. And then the court will put in place a visitation order. Now, again, do you ever want to get to this point? No. Do you ever want to have strangers intrude on your lives this way? No. So unless your former mother-in-law has abused or neglected your children, let them see their grandma. It's just that simple. If you have no safety concerns, let them see their grandparent. Because that's what the court's going to order. And you're going to go through a lot of time and money and heartache and public record. And that's what the court's going to order. So it's best to control your world yourself and be responsible. So that's how grandparents' rights work in Ohio. Okay, other states are different. Your book has a couple of different cases in here. And you can read through them. I'm not going to assign them to you. Okay? Remember that a court retains jurisdiction over the children until they reach an age of majority or have graduated from high school, whichever comes later. What if you move with the kids? Which court retains jurisdiction over them? You'd be surprised. The original court. Until it's transferred, that original court has tabs on those children. And there are some jurisdictional issues with that, but that is where we've ended up. So it's important to understand, if you are moving, to consult with the court to have jurisdiction transferred in case there's an issue in the future. Okay? All right, that's it for this chapter on custody. I know it kind of feels unsettled because we haven't talked about juvenile court issues with children who are born outside of wedlock. We haven't talked about child support, which goes with visitation, sort of. Not all the way, but sort of. We're going to talk about child support next week, and we'll be able to put most of this together, and then the following week we're going to talk about juvenile court, and that'll make the whole picture come together with children. Okay? Any questions? Please feel free to email me. Look for a discussion for vocabulary and an essay this week. Thanks.